And we are back. The Sean Diddy Combs trial is still ongoing, and a lot of you have a lot of questions. As you know, Kirsten Brown, a Los Angeles prosecutor, has been here 2 other times breaking down for you some of the legality that's happening in the Sean Diddy Combs trial. And look, I feel like I've gotten so much education from our conversations.
Here we go now.
So, of course, with all the closing arguments, and now we're in deliberations, she already predicted the timeline of how all this stuff would play out. And it's been on point, Kirsten. And we appreciate you weighing in via text during our recaps last week.
I hope I'm not being too presumptive because I'm sending you essays.
No. It was perfect because it really gave me an understanding of what we're hearing and sort of like, okay, I don't want to assume. And you really did provide a lot of clarity and some aha moments for me, especially when we talk about the unanimity aspect of what we read through in regards to what the prosecutors were seeking when it comes to the jury instructions. But before we get into all of that, welcome back, Kirsten Brown.
Hi, Kemp. I am so happy to be back. There's so much to talk about, so much to unpack, and it's wild that we're here because it kind of felt like we were going to be in this trial forever.
Yeah, I mean, it has been
forever. It has been, and now it's, potentially hours, if not days away from concluding. So I don't want to call it exciting because, a conviction for Diddy means significant prison time. An acquittal for Diddy means that his alleged victims go without justice. So, for us outsiders peering in, like, this is all super interesting and it's a lot of fodder for us to talk amongst ourselves. As a prosecutor and a legal nerd, the legal component is fascinating. Yeah. So I don't want to be flippant or make light of the seriousness of all this, but it's just, for lack of a better word, an exciting time to be here and dissecting what's happening.
And I have to say, and I'm glad you said that. However, I will say, based off of just learning more about this process and understanding, because again, we cover pop culture and there's a lot of stuff, especially when we talk about the legality of this, that we just don't understand. So I do get a little bit more, not necessarily excited. I don't know if excited is the right word, but definitely sort of like, oh, wow, I didn't know it worked that way, or how this all could play out. And it also makes you understand that despite what the media might be putting out there, and there's certain things that might be the little missing components, if you weren't an attorney, that you might be missing out on, how that really changes the narrative around what we're watching.
And also how some things aren't that big of a deal. I mean, it's interesting to report on and make a big deal out of, but it's actually really common.
Yeah.
Not to sound flippant about it, but Diddy not putting on a case, it has been heavily reported on and breathlessly talked about as, well, that's just how confident the defense is. The reality is, first of all, he's not required to put on a defense. He is constitutionally protected from having to do anything. His attorneys didn't need to cross-examine anybody. He doesn't need to call a single witness. He doesn't need to put on a shred of evidence whatsoever. He has no burden. It is entirely up to the prosecution. But the fact that he didn't is pretty typical, particularly in a case like this. Now, because his team suggested they were going to call witnesses and put people on, that's what we were all expecting. But when it came down to it, it's actually not that shocking that they didn't call witnesses. And I'm of the opinion that it doesn't necessarily project confidence, but it projects a better strategy, because what would a bunch of character witnesses that said, I think he's a great guy, I never saw X, Y, and Z, what does that do? Because the prosecution just hits play on the tape and says, person A, have you seen this before? Yes. Does that change your opinion of Diddy? And if that person says, no, it doesn't change my opinion. Well, like, you sound crazy because you saw this man beat a woman in the hallway. And if you say, yes, it changes my opinion, then how, important is your opinion? So strategically, I can understand why he wouldn't put on any witnesses. There's no affirmative defense, meaning like an alibi. Somebody else did it. A different theory of liability. Like, none of those things are at play here. It is just these women consented and I didn't violate federal law. That's a legal argument, not anything for witnesses to say.
Yeah, and that basically they're just trying to take down a successful Black man.
Correct. Correct.
Wow.
So they say.
So, so much played out. Those closing arguments. I mean, that probably because I haven't been going to inside the courtroom, but that probably would have been the time to go if I was going to go.
Yeah,
Ju-
because, even as comprehensive as the reporting is, when you're talking about hours-long argument, you can't get everything, and you get a sense or a vibe in the room of how these things are landing, what looks like it's resonating with people,
Mm,
where are they taking copious notes, where are they not? And we talked about before that doesn't necessarily tell you everything, but you'd probably have a different sense of what was happening or like, how the closing arguments went if you were in the courtroom versus reading the transcript. It's very, very different.
But it was even harder those days to get into the courtroom
Yeah.
because I knew journalists that were getting there at like 5 a.m. to make sure that they got into that room. The main courtroom was packed with his family, his friends, supporters as well. So it made it even harder to get into the courtroom last week.
And you know what? The prosecution, particularly federal prosecutors, don't play in the media. They don't try to use gamesmanship.
Mm,
However, witnesses and victims are allowed to come back and watch closing argument. If it
mm.
were me in a case like this, I would have brought at least Cassie right back into that courtroom to watch closing arguments as like a checkmate to Diddy supporters. Here's the people who testified against you. And I would have had them sitting in the courtroom as well.
Oh, I didn't think about that. I wonder why they didn't do that. Well, Cassie literally just gave birth, so
Correct. I mean, they may not have wanted to, it may not have crossed their mind. Again, prosecutors in particular don't tend to play in the media and try to do kind of have the same PR strategy that you would as from a defendant, particularly a celebrity defendant.
mm,
So, they might not have wanted the circus of it all. But again, for me, I would have wanted to have a counterbalance to some of the reporting about who was there supporting Diddy by having my victims in the courtroom to hear closing arguments as well, and having the jury see their faces one more time. It's been
mm,
5 weeks since
yeah,
they've seen Cassie,
yeah.
and bring her back and let all of that come back, particularly people who are visual and seeing someone's
Mm.
face helps you remember, help that testimony start, kind of like percolating in the back of your mind as they're hearing closing arguments.
And how does it benefit on the other side of the defense bringing, let's say, a Christina Kerm ended up coming to court on sitting on Diddy's side?
I mean, it would have been if, this is a joke, but I would have been like, "Can I reopen and put the," and like
Oh,
put
there
this
she is.
witness on? Yeah, I mean, it would have been that could have potentially been a checkmate because she came up so much. So they
Yeah.
could have had her, traipse in there holding a bottle of baby oil and KY and been like, "Here I am,
But I didn't
moisture."
I never even thought about that strategy from the prosecution's end, so I'm glad you brought that up. But I'm thinking probably part of some of what that could be is that Cassie literally just gave birth,
Right.
maybe, and I don't think Jane was what was your perspective on Jane's testimony? After how many days of being on the stand?
It was not as strong as Cassie's,
Yeah.
for sure. There were definitely nuggets in there, and then I think some of the text messages that came in through the summary witnesses were helpful,
Mm,
but if Jane was my only witness, I'd be more concerned.
yeah. Oof, 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 oof. In regards to like the other witnesses outside the victims, do you think they were strong for the prosecution?
I do. I think some of the Intercontinental Hotel employees were
Mm,
interesting. I think Cassie's mother was a good witness, especially because she wasn't cross-examined. I
yes.
think Kid Cudi was a good witness.
Yes.
And, his testimony, especially kind of like the non-dramatic way he just kind of recounted what happened, and it was, a serious allegation, and he was,
He
you
made the jury laugh.
yeah, and jurors like that, where you can bring a little bit of levity to something that's so serious, and that, like, tends to lend to someone's credibility. In little statements you say, I think I said this before, like the way he described Diddy as like a Marvel supervillain. It's
Yes.
like little statements like that that just ring true. That's not something you're making up. That's not something that, you're adding to be extra. That is like a genuine reaction to what was a very wild situation.
Yeah.
And so I thought he came across as very credible. The assistants were interesting because they, definitely gave another vantage point to what was happening.
Yeah.
And I also think it's interesting that no one hates him, even as
Mm.
wild as his behavior is. No one seemed like they were up there with a vendetta, even Jane, even Mia, like no one seemed like they were out to get them. And I thought that was something the prosecution could have leaned into.
Mm.
Even people who got money for him, even the defense said it. They might not have liked him, but they loved him. And even those who were suing him loved him because he was obviously charismatic
Yeah.
and someone who people wanted to be in his orbit, which I would argue emboldened him to behave badly because
Mm.
no one was going to do or say anything about it.
And I feel like the defense took what you just said and used that to their advantage in their
Correct.
closing, saying that
Correct.
all these people you're saying that were victims loved him. They talked about wanting to work with him again and all the things that they learned and they grew from and all of that. So it's so interesting that you're saying that the prosecution should have used that to their advantage. And it was the defense that really used that to their advantage.
Yeah, I think it was a missed opportunity for them to make a larger point about the type of person that he is.
Yeah.
And the almost hold he still kind of has over people, even, with them being far removed from his life.
Do you think Dr. Hughes, who really talked to cycles of abuse and why victims go back, do you think strategically it was the right time to have her, or should they have had her a little bit later on in the trial? Because I think some of that could have been lost.
I think in retrospect, she should have gone after all of the victims testified
Wow.
and then could have contextualized everybody. But there's, could be a variety of reasons why they called her when she did, including
Scheduling.
her availability. She could have only been available during that time period,
She's
or
expensive too.
she's expensive. And we heard so much from Cassie. So maybe after hearing from Cassie, it was like, okay, let's contextualize what you just heard from this woman and give you a lens to absorb the testimony from subsequent witnesses.
And I could be wrong, but I've covered a lot of this, and I feel as if they wanted to bring either her back or another expert, and
They
it
did
was like
wanna
a
bring
battle.
her back.
Okay, I wasn't
They
wrong.
did wanna bring her back, and I think the judge shut that down,
Yeah.
which could be an indicator that they felt like she went on too early and that they needed to, kind of remind the jury and use more, and you can't use specific examples, but make sure that her testimony was capturing the sentiment from all from Cassie, from Jane, and from Mia, who were all coming from a different place in
Mm,
terms of their relationship with him. Well, the 2 girlfriends and then the 1 assistant who he assaulted, but still had sort of she was very much enamored with him
yeah. Mm. So that is pretty interesting. Why do you think the judge decided not to allow them to bring her back?
to keep things moving.
Mm,
And, the judge could have said it's redundant. She's, in state court, in California state court, that would be called 352. And it's about judicial economy. It's about not having redundant arguments,
mm,
testimony that's cumulative, meaning someone has already testified to it. So it is going to be a taller order to recall a witness you already had on if you cannot demonstrate what would be different about their testimony the second time.
no.
And this is a judge who had a very tight rein on his courtroom and was about the schedule. A different judge might have said, okay, I'll give you a little bit of room here. But he was like, oh no, no, I told y'all this is the schedule we're sticking to.
Yeah.
Too
And
bad.
because of that is probably why we're so on time in regards
Very on time. Very on time.
to the who pays for Dr. Hughes. Is that paid by us?
Taxpayers, yeah, the experts do get paid, and there's coffers that exist within all prosecutorial offices to pay for experts, to pay for, you don't pay for victim testimony, but anybody who's considered an expert, so if they have a doctor in front of their name,
Yeah.
excluding a treating doctor. If,
Mhm.
for example, Cassie had gone to the emergency room and an emergency room doctor treated her injuries and you subpoenaed that person, they're not an expert. They'd just be a
They're
percipient.
obligated.
Correct.
Okay.
Right.
Okay. Because I know everyone's gonna be like, yeah. So who's paying for this? Maybe that might have been the judge's motivation as well. Like these are taxpayer dollars that we're spending to bring her back, and she's very expensive.
He's probably more concerned about the schedule.
Oh,
Like, we're not doing nothing redundant up in here. Keep it moving.
And I
Next
appreciate
witness.
that, Judge. We appreciate being kept on schedule.
Yes.
Well, and keeping us on schedule because you are in the office doing this. So we appreciate Kirsten being here and supporting
Oh,
us.
no problem. I had my judge today telling me to move it along
Oh,
with my witnesses, that they do that. Come to the bench, move it along.
okay. I will, and we can appreciate that. Going to the closing arguments in regards to who they decide does what. And and you laid this out for us. We knew that the rebuttal was coming. The prosecutors went first. It
Mhm.
was over 4 hours. They estimated it would be about 4 hours. It ended up being almost 5 hours, 4 hours and 49 minutes. Is that a good thing or a bad thing that it went over?
It's both. If the judge told the jury, "This is how long closing argument will be," and you exceed that, people are checking out. If I tell you our conversation is gonna be 20 minutes, at minute 22, 23, 24, you're starting to be like, you told me," and, like, mentally, you're not there. So that's the bad side of providing that context.
Mm,
However, given the amount of witnesses, the amount of evidence, the complexity of the law that needed to be explained, it's not surprising they took that long.
yeah,
But, the human capacity to listen is only so much.
yeah.
So I don't think most prosecutors want to give a closing argument that's lengthy, but you also have to meet your burden and you have to check every single box. And if that means I have to talk longer, then that's just what it is. Again, a judge is usually not shy about saying, "Counsel, how much time do you have left?" Which
He
is an
wasn't, and he
indication
definitely
of
wasn't shy
hurry up.
about that. Even during a direct and cross examination, just like, "Oh, okay, let's move this along." He
Yeah,
did that
that's definitely
specifically
code
during.
for hurry up.
Yeah, we definitely saw him doing that when the defense was questioning Cassie. Like, "Oh, are we gonna get to the point here?" Because it did
Mhm.
feel like they were sort of like dragging the testimony. He knew that Cassie had to be off the stand by a certain point. So we definitely saw that with this particular judge. In deciding who does the cross, well, not the cross, the closing argument, how does that work? Because, like you said, the prosecution, based on the people that were inside, that were weighing in on the different, the way that people presented. A lot of people said, and I wasn't sure about Mark Agnifilo
Yeah,
doing it. And I want to ask your perspective on them choosing him as
sure.
Diddy's lead attorney. But for the prosecution and them coming up with like for you in your case, if there are multiple prosecutors handling a case, how do you guys decide who's going to do what?
I have not had the pleasure of doing a case that there was 6 of us. That
Yeah.
is a lot of prosecutors, so it's a problem that I personally don't have often. At most, there'll be 2,
Mm,
and we've usually decided very early on, and that's
okay.
based on, kind of our, I won't even call it a weakness, but where do our strengths lie? I'm
Mm,
doing a trial with co-counsel in August, and he is a fantastic in rebuttal, and I
mm,
much prefer the first argument. So I already know I'll be doing that, and then he'll do rebuttal.
mm.
So sometimes it's just based on what your preference is and where your strengths lie, but we all have to do all of this by ourselves all the time. So they should have been able to have any one of those prosecutors stand up and be able to do not just one, but both arguments if they needed to.
One of the things that the defense in their arguments against the prosecution said that they utilized all of these resources in regards to the prosecution, and they had all these attorneys that were working on this case. So they used that as taking away from the prosecution and their case and the weight of their case. So I do recall that. But you're right. This is not all. This is not your typical type of case
No.
where you see this many prosecutors and resources being utilized for one particular case. But it's understood why, especially
Right,
when you have, I think it was AUSA Slavic that did the cross started, and then I think it was Maureen Comey who did the rebuttal.
right.
I don't know if you saw my summary of what Maureen said in regards.
Yes, I did, and her shots fired.
I was like, "Oh, to be in the courtroom when she said that," because she was basically saying that, yeah, you want to talk about Diddy confronting Kid Cudi, but he seems to not have that same energy for men. He has that energy only for women. That's not how she said it, but
Mhm.
that's basically what she said. I said,
He said, "Yeah, his girlfriend." I mean, Mark walked right into that. He
I
walked
love that
right
moment.
into that.
Especially because based on people in the courtroom have described Maureen Comey, she's very flat. And no offense, Maureen. I mean, she
Right?
doesn't show a lot of
Methodical.
emotion. Yes.
She's methodical.
Yes. And I believe she's the lead on this case as well.
Right.
But when she said, I said, oh, to be in the courtroom when she said that, because I probably would have been like, oh, right in court.
Mr. Agnifilo left a lot of room for some zingers to be thrown with some of his wild statements. So I'm glad that she hopped up and, said what she needed to say and kind of matched his energy because he, it was in such contrast to the closing argument before. So I'm sure he had the jury engaged and energized and, following along closer. So if Maureen had got up, I'm, saying first names like I know these people, but if she had gotten up and offered this other like flat,
Yes.
resuscitation of the facts, she, that wouldn't have been effective.
Yeah. From what I heard, and this is again why it's really great to be in the courtroom, because from what I heard, yes, Mark was very animated. I wasn't
Right.
even sure if he was the right person to do the closing argument, but based on what I heard, like he really put on a performance. Again, as you said, they don't have the burden of proof, so they could really be as theatrical as they want. But
Some defense attorneys are, they're a little more eccentric and
mm,
you get more of a pass for that being, less methodical than the prosecution because you don't have to prove your case.
yeah,
But it can also, go too far. I don't want to kind of veer us off our topic, but for me, now again, not having been in the courtroom and hearing the entire argument, not having heard the entire trial, for me, he was way too flippant
oh,
about the seriousness of this case.
mm,
Um, I get, like, this exaggerated way of kinda saying, like, the prosecution just did too much here, but we heard so much bad evidence, it felt flippant and dismissive in my view
yeah,
to stand up and present the closing argument the way he did. That being said, he is a white man of a certain age. There are some
mm,
white men of a certain age on that jury.
mm,
Probably workshopped, what his presentation was gonna be with the entire defense team, if not their jury consultants.
mhm,
So, it was a strategy around him getting up and taking that approach, and, and if you look at the internet, there's people who had that same energy about what happened. Like,
yeah,
what are we even doing here? You're just coming after a black man.
yeah,
So, it's not out of left field, but for me, I thought the defense had a lot to use in their closing argument. They
mm,
did an effective job with a lot of the witnesses throughout the trial. I thought they had a lot to argue, a lot to say to do a very effective closing argument. And so his flippant way and some of the comments like a modern day love story,
yes.
like the real men fight. Sorry if I sound like some of this kind of stuff was like, sir, are you crashing out up there? What is going on? But
But that's the energy, in all fairness, Kirsten, even before this case started, that was the energy he had been giving in interviews, the way that he was presenting that, through their court docs. This is how they were presenting, and like they're just coming. I really, like you said, I thought in their closing they would come stronger with the facts and with just certain point by point by point. But it was
right.
the same energy from even before the trial started, that they were being very like you said, flippant is probably the best word to describe it. But one of the things that I was actually surprised that they chose him to do the closing argument, but you really bring up a valid point. When you look at the makeup of the jury, they probably would take that sort of attitude better from him than if Xavier Donaldson went up there and did it.
Right, they might have, and I would have been curious to see. I'm curious to know how his DEI that he was doing DEI before DEI was a thing,
Mm,
how that landed,
right?
and if that would have come across different because I'm also like and I think you said it, like, you have a history of treating your employees badly.
Terrible.
You haven't paid artists. There was a whole show about being your assistant where you acted a whole fool.
Yeah,
Like, there is not people generally speaking out here like he was a pleasure to work for or a pleasure to be around.
yeah.
So, I was just like, I don't know if you get
And
credit for
cheap.
being
Did
a
you hear about
and cheap.
the part about when he talking about the Cowboys for Angels, saying he can get a discount?
But you
Sir.
know what? They do say that's how wealthy people stay wealthy. right? They're out there
I will forever be poor.
negotiating prices about everything.
It's crazy to me. It's crazy. Oh, sidebar. I did hear Jeff Bezos didn't want to pay Lady Gaga and Elton John $6 million to perform at his billionaire wedding. So you're right. So maybe he's the richest man in the world. You can't pay
I
$6 million.
come on. And the whole event was like over 50, but maybe he felt like for Elton John, I mean, I don't that sounds about right. Don't they usually anyway, that's a whole other conversation.
but,
But yeah,
but it's
like
all
it's
relative when you think
interesting
about it.
where you decide to get cheap. So yeah, and that's what's interesting too in thinking about the makeup of the jury.
Mm,
Is there anybody on that jury that just has sort of a pop cultural understanding of the full scope of Diddy? We talked very early on about how significant he is for the culture,
yeah.
and him being a respected mogul, and he absolutely is an entrepreneur that built himself out of nothing and had all of these brands that we were all clamoring for. But you have like 99 kids by a lot of different people, and this, toxic relationship that was the love of your life. And in the back of my mind, I was like, I thought Kim was the love of your life. So just someone who kind of has like the T kind of backstory to Diddy that might be listening to some of his arguments, like, what are you talking about? Y-
Mhm.
like,
Especially when you have multiple assistants testifying, even though they may have love for him. But again, when we talk about cycles of abuse, that it's not just in personal love
yeah.
relationships. That
Did
happens in
any
work
of them
environment.
see Making the Band? Do any of you remember them trekking across the bridge to go get a cheesecake and the hollering and the fussing and and that's not
And that's
evidence
on
in this
camera.
case. Right. But just as if I was on that jury, as Mark Agnifilo was painting this picture of this omnipotent Black man that wanted to do nothing but lift up the community in support, there's a lot of backstory about his life, even separate from this trial. And I'm just curious if there's anyone on that panel
That knows it.
that knows it, even kind of tangentially.
Mm. I mean, it would be interesting to see, but even before we even got to closing arguments, the conversation in regards to what would be included in these jury instructions, and we
Mhm.
went through the prosecution's requests, and I'm so glad that I sent it to you in regards to, because you highlighted the unanimity aspect, and then you talked a little bit about that. So just refresh everyone's mind on what you felt after reading that particular question that came up in the prosecution's effort for the jury instructions.
Sure. So, jury instructions are incredibly important, and it's something that both sides make suggestions and edits to. The judge pulls them, and then you have to argue for sometimes specific language or lesser included, which I think was an issue today of them arguing about including lessers, a big, big deal. But one in particular, the prosecution asked for there not to be unanimity instruction, meaning for all of those predicate acts, there did not need to be a unanimous decision.
Mm,
So juror one could say, I believed that there was kidnapping and bribery. And juror two could have said, I believe that there was sex trafficking and forced labor, and so on and so forth. They didn't have to agree on those acts. But
mm,
apparently, the prosecution did not get that instruction. So there has to be a unanimous decision on what predicate acts they agree on.
yeah,
And that, like, the burden's already high, and it just takes it to the next level because you need all 12 to say yes or no for those predicates. And granted, they only need two.
yeah.
And I think they got them, but this case is just so
But when you brought that up, I don't think then, because people think this is so black and white. But if the judge had said that's fine, this could change the whole dynamic of the
completely,
verdict.
completely, because everyone can have a different opinion about why he's guilty. Again, it needs to be unanimous that he committed the racketeering conspiracy.
Yeah.
But the actions of the why of it all could have been everybody's individual opinion.
Mm,
And to have to get everyone on the same page about all of it is just a greater challenge on a case like this that, was no slam dunk
no,
from the get-go.
no, not at all. So why do you think the judge decided not to allow that in the final jury
I
instructions,
mean,
which were
these
like 60 something pages?
yeah, jury instructions are always super long because it's the law and it gives you instructions about everything and it defines terms. They're very important. It is the second most important thing, well, the third, besides picking a jury, evidentiary rulings, like what evidence can come in and not, and then
Mm.
your jury instructions. So it's really, really important. I forgot your question.
In regards to why do you think the judge decided not to
Oh,
include
I
it?
mean, it's not an arbitrary decision. It's gonna be one that's based on case law
Mm,
more often than not, or what's common practice based on case law in the 2nd district, which is where the Southern District of New York is.
yeah.
So, I'm sure the judge pulled some authority
Mm,
and actually had to make a record about why he was or was not going to include certain instructions. He can't just say, "Well, you make a good point," or "I agree with you," or "I don't." It has to be based in the law. So
wow.
his research must have indicated that there was not sufficient case authority to include that instruction on this charge.
And if he did, let's say he based it on something and he decided, yes, we can keep it, that would this particular case could change other cases in the future.
Right, and appellate issue, because if it's sort of a case of first impression, in which it kind of is, I don't know that a RICO statute has been used this way before. So a
Mm,
case of first impression is when something is brand new or it's novel.
yeah.
That immediately would have been appealed. It doesn't mean they would have necessarily won it on appeal, but that's creating yet another appellate issue for how the instructions go.
And that's why I feel like the final verdict in this case is going to be very interesting for how
Mhm.
they move forward with other RICO cases as well.
I completely agree. It is a novel theory. And what's interesting is you look at the plain language of the statute and it's not that complicated.
Mm,
It's, an enterprise and everyone working towards the one goal and then the predicate acts.
mm,
But how those facts came to life in this case is more complicated. And there's so many questions as simple as, can the enterprise have legitimate business means? Right?
mm,
Because we know there was a record label, we know there was vodka, there was a clothing brand, etcetera, so there was legitimate businesses, and so that's why listening to the whole argument from the prosecution, would have been important to see that they touch on answering questions like, yes, he can have a legitimate business and still have a criminal motive,
mm,
and that criminal motive does not need to be attributed to the rest of his employees. It could have just been for him in his own
mm.
sexual gratification. He wasn't making money off these freak offs or king nights. This
Yeah.
was purely for his own gratification. And how does that fit within the statute? That's what makes it so complicated.
And this is why
Yeah.
so many people are so confused. They're like, "Oh, free Diddy,"
Right.
because they're like, this is not S trafficking and this is not RICO.
Right.
Well, we shall see how
Very
they
soon.
determine this. Before we even get back into it, because we definitely need to get back into that. But I think it was last week. These weeks are all coming together
I know,
where
right?
every media outlet was reporting, not everyone, a lot of blogs were reporting that they dropped charges against Diddy, and everyone's like, "Free Diddy! See, they don't have a case. They're dropping charges." That's not true. All the charges still remain. However, certain allegations were decided to be removed and streamlined. This is what the prosecution is saying, that they were trying to
Right.
streamline. Have you ever seen anything like that before? And can you at least explain to us laymen what exactly was happening there and why they
Sure.
decided to do that?
Yes, I'm doing it now. I'm actively in a trial, so I won't give any specifics
Yeah.
since it's currently pending, but I decided not to proceed on 2 of the charges
Mm,
and proceed on 3 others. I can prove them,
mhm.
but it would have been more complicated for the jury to deliberate in the end, and I didn't get much for it by keeping those charges in.
Okay.
So it's not uncommon for you to, as a prosecutor, pursue a certain set of charges, up until including trial, and then streamline that a little bit based on how the evidence came in, and sometimes even add charges. It's called conforming to proof.
Oh,
Like we heard more evidence about something happening, just for example, a new SA or a new R. I have evidence of that now, so I'm going to add a new charge
mhm.
before I do closing arguments and before the jury deliberates. So not uncommon. And what they did here was in the predicate acts, they had some attempts alleged. I think it was attempted bribery,
Mhm.
attempted kidnapping,
Arson, I think, was also mentioned.
attempted arson, right. So to make it a little bit cleaner and help get all 12 people to agree about whether or not the acts were true, they scaled back on what an attempt is versus the facts they have for it actually being executed.
Mm,
Executed arson or an executed bribery. And so it's going to make it and it made the you shared the verdict form with me, and it actually
yeah.
is very clean and simple and easier to understand. So you make decisions like that to aid the jury in deliberations along the way.
Especially because the case already, we were just talking about how complicated this is.
Mhm.
So for me, at first, when I
Very.
saw the headlines, I was like, "Wait, what do you mean? What do you mean?" But of course, after a little bit more digging and understanding of what was happening, that it wasn't what people were reporting. But it made more sense when we talk about how complicated this case is and how a lot of prosecutors are saying we haven't seen anything like this before. Um,
Right.
so
It
that
was
makes me
streamlining the predicates. That's the way I read it. It was streamlining those predicate acts and going with the ones that there was the strongest evidence for.
and he still facing the same 5 charges.
Right. Correct.
Okay. All right. Guys, if you're just joining us, we're here with Los Angeles prosecutor Kirsten Brown. Yet again, if you missed it, we did 2 other conversations, very long conversations, but such educational conversation. I feel like I am so smart when it comes to this case. So we do really, really, really appreciate you breaking this down for us in layman's terms so that we have a better understanding of what we're watching. So we talked about them, streamlining those charges. We talked a little bit about the closing arguments. Based on the rebuttal argument, so, unless there were other things that you wanted to mention in regards to the defense's closing arguments versus the prosecution's arguments. If you don't have anything in regards to that, let's talk about this rebuttal and if you felt like the rebuttal was sufficient in really bringing home what they needed to bring home when it comes to the prosecution.
I feel like the rebuttal didn't get as much coverage as the closing did,
Mm.
and I'm curious about, and Kemp, maybe did either the defense or the prosecution use a PowerPoint presentation or any kind of visual aids, or were they just talking?
There
'Cause
I
that matters too.
Yeah, I believe the defense definitely had, like a poster board. I might be wrong about that, but I vaguely remember one of the journalists reporting that there was a poster board. I don't recall whether or not I would assume, though, the prosecution
I
did.
I would assume too, because you want to give the visualization of what you're saying.
Yeah.
It's also a guide of what the jury can be writing down to help them deliberate.
Mhm.
So I'm very, very curious about that. I can't imagine they didn't because there's just so much.
Yeah.
There is so much here, and the instructions were so long,
Yeah.
and they got the instructions after parties gave their arguments, which I think is even harder because you can't then explain what you just heard from the judge. And you think you might have got it as a jury. You're like, oh, okay, I just need to do X, Y, and Z. And then the judge reads this complicated language, and you're like, wait, it doesn't necessarily make sense anymore. So it's hard to say if the rebuttal landed the way that it needed to,
Mhm.
but it does seem like she matched Mark Agniflo's energy.
Yeah.
She definitely gave it right back to him in some of the areas where he, kind of opened the door that the, real men fight, and for her to get up and say, yeah, his girlfriends, like stuff like that. She definitely needed to give that back to him. And I hope that she closed the loop on and I think she did. And in fact, there was some reporting about how it was him being so rich and powerful was the reason why he felt like he was above the law and like no one could say no to him.
Yeah.
And I know the defense really tried to use that to paint him as this great guy, and it's a yes and. He could be a wonderful entrepreneur and business person. He could be a terrible person. He could have been a really good father, but a terrible boyfriend.
Mm.
And it's incumbent on the prosecution to really drive home the yes and the dichotomy of it all.
Yeah.
And it's the fact that he's rich, powerful, adored, charismatic, all those things about why he behaved the way he did for decades.
Yeah. They talked about his body. Again, this is another benefit. And shout out to all the journalists and media outlets that were in the room. They were talking about how different his body language was on the day of the prosecution's closing arguments. They said he was
Mhm.
far from the table. He seemed disengaged. He was definitely more engaged when the defense were doing their closing arguments. He was more like himself, according to journalists that were in the room. What does that say as someone that's done this and then that has paid attention to defendants facing maybe similar charges or if not worse? What was your assessment of hearing about his body language? Even today, they were talking about his body language in court. He was like tapping his leg. He seemed a little bit nervous. Understandable. You're facing life in
Right,
prison. But what
right.
was your assessment on hearing that?
All of that tracks.
Mm,
I mean, you are during your if you're a defendant and the prosecution's closing, like, it's the equivalent of them letting you have it,
mm.
like laying you out to bear. And some cases are a lot stronger than others, and some of it is just like, woof, like the prosecution finishes and it's like, what are we even doing here? Give me this verdict form right now. And that energy is going to be, present. It's difficult to mask that. I think last week you had asked about his wardrobe and why he
Oh,
was wearing
yes, yes. Thank
the
you for
Hamptons
remembering.
tan suit.
Yes. I really went on a tangent. I could have.
It
There
was
were a few
funny
questions. I
though.
was speaking directly to you during our service last week. I don't know if you have those questions in front of you, but I would love
You know
to
what? They're
answer.
actually on my phone. I do
Yes,
have them.
please.
It was about the tan suit, and then when the judge said that a part of Mr. Agnifalo's argument was grossly inappropriate.
Yes. See, I'm glad you wrote those
Can
down.
definitely talk about that.
Uh,
So, it seems kind of in 2025, what I'm noticing is the defendant outfit du jour is a sweater vest and glasses.
mm,
So, looking Mr. Rogers like demure, someone's grandpa is absolutely intentional.
okay.
And the light colors, again, I've used the word workshopping a lot, but he has a team and they have consultants and they workshopped what's going to play best.
Mm.
And so they must have thought, the Obama tan suit was the way to go. And
He was
maybe,
wearing white, they said. He had, like, a white sweater on. I was like, "He's trying to give us
now,
heavenly."
when the power of white was dissected during Johnny Depp and Amber Heard's trial,
Yes.
and Johnny Depp's attorney, Camille, and I apologize, I can't remember her last name, but she was wearing a white suit when she cross-examined Amber Heard, and that was much dissected on the power of white
Mm,
on, a person in the courtroom.
yeah.
So, with that thinking, putting Diddy in white makes a lot of sense. And like, look, he's wild, but white does look good on chocolate skin, let's be honest.
We can wear some
So
colors.
yeah, we can wear color, we can wear white. So, and then his little salt and pepper hair and
Yeah,
some
but give him wearing Mr.
glasses.
Rogers, because as
Yeah,
I was saying it, I was like, "Why didn't he have him in, like, a nice suit and, maybe, like, navy blue?" And I thought about it, well, then it would probably it would continue that same narrative that he's probably, like, this hard, terrible
right,
human being if he was in, like, a suit, but if he's in a nice sweater like grandpa and he's all gray and white hair, they probably looking at they probably don't even see Diddy
right,
because Diddy doesn't look
right,
like Diddy right now, y'all.
right. And the only other image you have of him is, well, the freak offs in the background, oiled up,
Okay,
and
saw that.
then in the towel in the Intercontinental Hotel. So they I'm sure were very intentional about the image they wanted to portray with him for
Mm.
the duration of this trial.
Well,
And wasn't
oh,
he holding a Bible at one point too, which is also like classic, I think very early on, like jury selection. He had a Bible
mm,
sitting on counsel table. Again, like classic defendant behavior to
mm.
come out with the rosary beads, a Bible, the sweater vest, the glasses, a notepad full of nothing.
They said he was taking all kinds of notes and then passing Post-it notes to his attorneys. They said he was like a lead attorney on his legal team there.
I don't know whether or not they appreciated that because oftentimes, and I experienced this working with some pro per, so defendants who represent themselves, and in talking, I have a lot of friends who are defense attorneys.
Mm,
Defendants can get hung up on something that they think is incredibly important, and it's literally not relevant. It's not going to move the needle one way or the other, but it's a fact that they're kind of hung up on,
mm,
But to contrast that, he, outside of the people testifying, has the most information in the courtroom about what they're saying. So if he actually is being a productive member of the defense team, he's providing a lot of context
Okay.
for, what the witnesses are testifying
Or if
to.
they're
He
lying,
should
like,
have
"Oh, no,
got
that's not
if they're
true."
lying, right? He shouldn't have gotten a copy of those text messages and been able to, like, what your text exchanges with people have been. So
Mhm.
if you give me a copy of that, I can be like, oh no, on this day we were fighting, and on this day it was all good. Oh, here's one where they were threatening me. So
Mm,
he would have been even, almost like a paralegal in going
mm.
through that type of evidence and directing his team to what was important.
And we have to also remember, this is not the first time he's been a defendant, and we have to at some point, you become an expert when you're fighting for your life. This is not the first time that he's been on trial. Just
You're
saying.
you're not wrong.
You become an expert. I feel like an expert after these conversations with you. I mean, I'm not trying to go to the SDNY, but so he probably
You
does
are
feel a little
you
bit of
are not wrong. You are not wrong.
one of the things that I mentioned in the summary when they were doing the closing was I noticed how they started off with Jane's testimony, us talking about how maybe Jane's testimony wasn't that strong, but they
Mhm.
ended more so with Cassie in their closing arguments. And I thought that was very strategic, especially because Cassie had testified weeks ago. What were
Right.
your thoughts on that?
That primacy and recency,
Mm,
so, what do you want the people to remember last, and kind of connecting it to the first witness that they talked about. Again, I thought he was off in his description of their relationship and kind of
mm,
his assessment of Cassie. I think that it was wild to me to be using the audio of her confronting her friend
yeah,
who had allegedly seen a sex tape, and she's talking about "I'll kill you," and sort of implying, if not outright saying, well, you hear her here. Clearly, she can't be a victim of domestic violence, or she can't be abused, because you hear her talking to this other person threatening to kill him,
yeah,
even though, one, it's clearly done out of fear
yeah.
in an effort to make sure no tape comes out, and two, the irony of all of these reasons why Cassie is quote unquote gangsta.
Mm.
She had a burner phone, so she's carrying
Right?
on relationships. She was on the phone talking to somebody crazy, and I'm like, "It sounds like your client. So why is
Learn from
she
the best.
the" Yeah, and, like, like, can't be credible for all of the same things that your client is accused of doing. It was wild to me. What he should have just left it with is, "Look," and I think I said this before, if we were in state court, I would be the first person to say he's guilty,
Mm,
but we're not. Miss Ventura had two options to deal with the domestic violence that she endured: state court charges or a civil case. She declined state court charges, even though she had up to 5 years after the
mm,
incident happened, and she claims there's multiple ones. She never decided to pursue criminal charges. That's her objective. Her remedy was monetary, and she's been compensated. The book on this has been closed. It
mm.
looks bad. Like, like, none of us like this from our client, but that chapter's closed. It's not sex trafficking, and she's been compensated for it, so you don't need to consider it here. Instead of just being like, "Oh yeah, he wanted his phone." And, like, what?
Yeah.
And then to play a clip, one clip where he's holding his phone. We don't know if he snatched her phone. We don't, like,
I do feel like
what
the
are we talking
defense,
about?
and again, all attorneys are going to be very different in how they present their cases or their defense. Even before the trial started, just the interviews that Mark was doing, I was just like, "Oof, you're paying millions. He's being paid millions
Yeah,
of dollars to defend Diddy."
yeah.
I did hear that Mark's wife, who's also defending Louis Maggione, was in court, and she was very proud of her husband and his and his closing arguments. I mean, it's her
I mean,
husband, so
he is a successful defense attorney,
yeah,
which is why he was hired, which is why he was every single person he had on his team.
yeah.
Anyone could have gone up there and and done a solid closing argument. That's what you're paying for. If if you're rich and you were ever in criminal trouble, any variety of those people are who you would want on your team.
Mark
Um,
Garagos, the daughters.
Mark Garrigo, correct. Tenny, all of them. But again, for me, that closing did not land. And I'm even taking my prosecutor, like, hat
Mhm.
off to try to not be biased. It was just too flippant and unserious for
Mm.
how much serious stuff we heard.
Yeah.
But, it remains to be seen if at least some, if not all of the jurors are kind of like, yeah, they did go too far.
Mm.
The
In regards
prosecution.
in regards to the question that I sent you, because I think it's related to what we were just talking about in regards to the judge talking about Mark being inappropriate. Can you
Right.
answer that? What was my question again?
It
Because it was
was
something.
so during the break, I believe Maureen Comey made some type of objection about the inappropriate argument that Mr. Agnifilo was giving, and the judge agreed and said that it was grossly inappropriate. He had something to the effect if he had crossed the line. I think he gave a curative instruction to the jury or admonished the jury
Mm,
to disregard how he had been framing that argument.
mm,
The way that came across to me is the jury cannot consider punishment at all. It would be inappropriate for them to consider punishment when they're deliberating.
okay.
It can't weigh into your decision making. That's for the judge only.
Mm,
And if, as either the defense or the prosecution, you're implying a significant sentence attached to one charge, which he was doing with the RICO. He was like,
mm,
the prosecution could have charged him with other crimes, but they went for the most serious crime available or something to that effect.
mhm.
And so while he didn't say explicitly he could be in prison for life because of this, it was sort of implied
Oh,
based on like he's saying that this is such a high level and it's beyond the pale, and there's a myriad of lesser, kind of crimes he could have been charged with, and they went for the top. And so that's where you start to get into inappropriate territory.
okay. So now that makes a lot more sense to me. All right. So we already kept you here almost an hour. So I do want to get to this Okay, wait. Before we get to the verdict sheet, juror number 25. And I have the question because so they sent a couple of notes during the day. So they got their instructions, 60 something pages of instructions. So they
Mhm.
sent a couple of notes to the judge. Shout out to Fox, oh no, it's ABC News 7 for this. So they said note one, choice of the form person. I'm guessing that's practical. That's what they normally do. So they sent a note.
I mean,
No? Okay, see, that's what I'm asking. They sent a note.
like, the judge tells you you go back there and you elect a four-person. So, they like, or, I take that back. In federal court, it could be that a certain juror number is the four-person. I'm gonna have to do some research on that and get back to you.
Hmm.
In state court, the jury decides who the four-person is. It
I
is
think here too,
possible.
because when I listened to this actual report, they mentioned that they selected.
Okay, so,
Yeah.
it's the purview of the 12 in the box. We call them the 12 deliberating jurors to select their four-person,
So what
uh,
happens to the
alternates.
yeah, there we go.
They have
You're
to
done?
they have to stay in the courtroom because they
Oh,
could be subbed in not the courtroom, the courthouse.
yeah.
So they could be in the cafeteria, they could be down in the jury room. They don't participate in deliberations. They're just on
Yeah.
standby, and they can't talk to each other
I'm
about
about
the
to
case.
say, so they're just like this, twiddling their thumbs all
It's
damn.
the worst to hear all of this, and then when it's time to get in the game, you're benched. It's
Wow.
the worst.
However, after this case is done, they could talk and write a book if they wanted.
Correct, correct.
I hope they
And
do.
not have had the pressure of being a part of whatever decision it is. And then, if the world is coming for the jurors for how they decided, they'd be like, "Well, I would have voted differently. And here's
Mm,
why." So it's from the monetization and media perspective on the other side, it's an advantage, but it's
yeah.
also incredibly difficult to have been through this whole process, and then it's time for the important stuff and you have to go have a seat.
Yeah. Oof. Oof. So they had their choice of a four-person. Note two, questioning the juror's ability to follow instructions. Juror number 25. So they sent a note to the judge.
They
They wanted
called
the
him
judge.
out.
Yes, they wanted him to. That probably would have been me if I was a four-person. Something's wrong with him. Because we were dealing with different personalities. And as you said, you're intermingling with these people week after week. You're probably noticing even though you're not talking about the case, you're probably noticing like something ain't right with that person.
Right. Or, in the attorneys won't speak about it now, but afterwards, was he interacting with the other jurors throughout the course of this trial, or was he a bit of a loner, kind
Mm,
of off doing his own thing? Because that can be instructive too in terms of how he's going to play in the sandbox when it's time.
Yeah.
I'm proud of the jury for sending this note out. I think it may have been during conversation 1. I can't recall at this point if I mentioned here. I always tell the jury, send a note to the judge. If someone is not, I've voir dire on how well people play together as a team. And if something's happening in that jury room that doesn't quite seem right, send a note and let us know. Don't.
Can you explain what voir dire is again? Because we talked about that. That's come up. Can you
Yes.
explain what that is? I don't want to brush over
That's
for
the
our
jury
clients.
selection process.
Okay.
So back when they're selecting a jury, you know, you have an opportunity to ask a number of questions. Excuse me, I'm just getting over a cold.
Oh no.
And one that can be, there's 2 actually that can be very instructive, and I'll be curious if they did it too. One is whether or not someone either works on a team, has ever played a team sport, or likes to work in a group. And you're using that to remind the jury that your verdict is individual, but being in deliberations is a group project. You have to talk, you have to participate, you have to listen, and then you render your own individual verdict. And sometimes there's people who like, yeah, I don't like people. I don't want, like, I'm not going and that might not be somebody that you want to be a part of a deliberative process.
Yeah.
The second thing that I'd be curious if the prosecution voir dired or asked questions about is, to put it very simply, asking the prospective jurors, if I can prove the case beyond a reasonable doubt for a law that you don't like, will you still convict? I do a very extreme example of, let's say there's a law that you can only drive 17 miles per hour when you go past Costco or Target. That's the law. It's what it is. And I prove that this defendant was driving 20 miles per hour past a Costco on this date, and I've proven it beyond a reasonable doubt. Even if you don't like that law, even if you think it's dumb, even if you think he shouldn't have been charged at all of those things, and I prove this case to you beyond a reasonable doubt, can you still convict? And you're kind of priming people to think, hey, RICO's going to sound weird to you in this context.
Yeah.
You might not like it being applied to sex trafficking charges when in your mind it should be with the mob. But if I prove it, if I prove these predicates, each of them beyond a reasonable doubt, can you convict, even if you don't like it? And so that's what you're starting to set them up to think about, because you might have some jurors back there who were like, because I think the prosecution proved their case.
Yeah.
The next hurdle in a case like this is getting buy-in. Can you get 12 people that says, yes, like, this kind of behavior does constitute RICO. It's bad and I don't like it, and that's one thing, but when I look at the elements, it constitutes RICO. That's like part 2 beyond just proving the element. So that's what gives me pause in this case, not whether or not they proved it. I think for the jurors who want to convict, you have the evidence to do that.
Yeah.
But did you bring it home for the people who might be like, does this really fit? I don't know. I think I texted you the example of Trump, where everybody was like, like, now I can't think of what it was, but it was like falsifying business records. When it wasn't really in question whether or not he knew Stormy Daniels, that they had something going on, and that he paid her off. It's like a given, and no one was saying that wasn't true. But the question was, but is that payoff and how it happened falsifying business records? Or is it something private and personal? And
We're going to revisit that because
to explain that.
There's a question in one of the last notes, which the judge will answer in the morning. They say, because the judge leaves it in their hands, the jury decides, how long they're going to continue to work on this. They decided to leave like around, I think it was like 5 o'clock. They ended up leaving for the day. So we had the question around that particular juror. the judge met with the juror. It seemed like they were fine for the rest of the
Oh,
day.
did they?
Yeah.
Oh, okay. And I was trying to get up to speed a little bit before I hopped on with you, and there was some speculation that implied that this juror is a holdout.
Mm,
And at least on some, if not all of the counts, that 11 people likely were voting guilty and he was not.
yeah.
Um,
And they were saying that he couldn't follow instructions. But
right.
apparently after meeting with the judge, they decided to be able to move forward with it.
No, the judge gathered him.
I don't know what he was like a 51-year-old professor. Well,
Mechanic
oh, you know,
or engineer, something
PhD
like that.
in neuroscience, and I have it in front of me. I have all of
Now,
it.
what did I say
I
from the
remember.
last
We talked
talk?
about this in part one. We talked about this in part
And
one.
this is exactly why, because he's smart. He's, at least by his degree, you're smart, and you're in there picking the language apart.
Yeah. Yeah. Let me just see, because I know I have it here in juror number 25 in regards to where is it? I know he has his PhD in like neuroscience and something else. Where is it? Oh, yeah, so it does not follow jury instructions. The juror was is replaced. Where is it? It's literally right in front of my face, and I can't find it. Where's his? They mentioned his PhD. Let me just
Mm,
search this document, guys. Bear
see?
with me.
Red flag.
Let me see. Neuros. It was not coming up. I just know this man has a PhD in like neuroscience and something else. That, and I thought that was interesting. Like, oh, we talked about people that have this particular expertise. But again, the thing that they noted in NBC News' report, they said that it does not follow the judge's instructions. Jury number 3 in this article. Who's number 25?
Is juror number 3 the foreperson? Was the note signed by juror number 3?
They didn't say if it was a foreperson. Based on the article that I saw or the report that I saw, they didn't say if it was the foreperson that had sent the note to the judge.
Now, usually it is, and the parties can know because you get to look at the question. And so it'll be
Mhm.
signed by the foreperson as juror number. And it's also really, again, not reading too much into it, but can be very instructive to know who your foreperson is. And if it's a good foreperson and you felt like it was someone who you were connecting with, and is it the type of person, going back to voir dire, that could usher together a group and lead them through what could be a complicated deliberative process.
Mm. That was very interesting today. But like I said,
Which,
they were
yes,
they were
very.
able to get over the hump of whatever the issue was with this particular person. But this next note was really interesting because how to understand narcotics distribution allegations. So
And
I was
see, here's what sucks.
go ahead.
The judge is just gonna point them back to their packet of jury instructions.
Ooh.
There's no added explanation, there's no additional details, there's no, "Oh, well, let me break it down to you like this." He's going to refer them back to that packet and
Mm,
say, "Look at reread the instructions that I've given to you."
okay.
And, like, there's nothing worse than being an attorney and knowing the jury is asking for an explanation about something and you can't give it.
Mm.
Unless at some point they ask for re-argument, which is a possibility. If
Oh.
they're hung and the judge, can offer, would re-argument help? But
Mm.
otherwise, no, they have to refer back to the packet, no further details.
So based on ABC's report, they said their question in regards to this was if an individual asks for a controlled substance and the person hands it over, is that considered distribution?
Ooh.
And one of the attorneys that were hearing
Why
that,
didn't the prosecutor say yes in the closing argument? That example should have already been provided, because yes, per the law, yes, but clearly they didn't say it.
so it'll be interesting to see what the judge says in the morning about this. But I
He's
thought
gonna
that
have
was
to
a
repeat the
very interesting
packet.
question. But here's the thing, one of the attorneys or defense attorney that I saw unpacking this, they said the fact that they're asking that so early on, s they are thinking that, "Alright, so have they already decided that this is RICO?"
Again, it depends, and which could be interesting. It could lead to what some people are speculating, that they have a holdout, that they walked in the door like, "Should we take a vote real quick, y'all? Guilty?
Mm.
Okay, and, on what counts, and then let's talk about what we need to," and one person was like, "Nope, I'm not doing it, I need to hear more," whatever the case may be. It's also possible
Mm.
it's the other way around, that 11 people were like, "Do we think he's not guilty? Yeah, let's vote," and one person is saying no,
Yeah.
but it's probably more likely that it's for guilt. But jurors also don't always deliberate in order. And this is the power of your four-person. Do you want to start with what's hard and work through that? Or were they struggling with what's hard and they say, okay, let's go to the easier counts, or the
Mhm.
ones that are maybe a quicker conversation, and we work from there? Again, I'd be curious, during the prosecution's closing arguments, did you give guidance on how to deliberate?
Interesting.
I do, especially depending on the case. You tell the jury it's up to them alone to decide how they would deliberate, but my suggestion would be to do this.
Yeah.
Based on these facts, start with count 2, and like actually give them instructions on how they should move through the process, and they can accept or reject that.
Mm.
But that's a hard question to answer, because it could very easily be going out of order, very easily,
Yeah,
because
yeah,
they can quickly dismiss one thing but not another,
yeah.
or they think something is harder or easier, and so they're skipping around.
Okay.
Or they already voted on all those things, and they're like, "This is the last thing we have to decide."
Wow. Because
Hard to say.
I think you and I already knew based off our last conversation, because people were, like, waiting, like, "Oh my god, we might get a verdict today." I was like, "I don't think we're getting a verdict today, guys." It's too complicated, the case,
It's
and
too
the morning was
complicated.
spent going through the 60 pages of jury instructions. I
And
was like, "I
I'll
don't think we're
say
gonna."
this, let's say they did vote and they know how they're voting. They
Mm,
were not coming out today with a verdict. To
okay.
catch all the heat,
Oh,
like,
oh,
from,
oh.
especially if their identities are ever disclosed, there was just a 6-week trial, and if any of them at all, again, can reference OJ and the way those jurors were criticized for
Mm,
their too quick deliberations for a 9-month trial, you
mm,
just got through 7 weeks, you're not coming back the same day you went out with verdicts. So
mm.
they could have voted and then been chit-chatting for the rest of the afternoon and said, "By about noon tomorrow, we'll let everybody know." Again, bald speculation.
And
I
it's
don't know.
and that's really up to them. At this particular point,
Completely up to them.
this is their rules now.
And if they're smart, there was no way, even if they knew how they were voting, there's no way you're coming back in that courtroom the day you go out to deliberate on this trial.
And that wouldn't have been a good
Verdict.
sign for the defense.
Yeah, the general rule of thumb is quick verdicts tend to go towards the prosecution, because people don't typically acquit quickly. They deliberate about that a little bit longer, and
Mm,
that longer deliberations tend to favor the prosecution. There's so much fodder here.
yeah.
I don't know that you can read it to a one way or the other.
Mm,
In a very slam dunk case, when people are deliberating for a long time, it gets scary, because it's like, on video, DNA, defendant admitted, like, I've given you soup to nuts every possible piece of evidence you can get. Why are you talking 3 days later?
mm,
Versus a case like this where there's a lot to unpack,
yeah.
wouldn't be surprising if they're talking 3 days later.
Mm, mm, okay. All right. And then the final note was like, "Can we go home? We're done for the day." I don't
Yeah,
blame
we're
them.
not staying late.
Do you think there will be a verdict this week, though?
I do.
Yeah.
I
Like,
know
fourth on Friday, we're not trying to come back next week.
they or you know what? Sometimes people I had a colleague who did a trial that ended on December 23rd, and everybody was like, "Oh, these jurors will be back right away. Nobody's trying to be here over, Christmas, Hanukkah, etc." Those jurors deliberated 11 days. They took Christmas off and were back on December 26th.
What?
And yeah, so
How
sometimes you get
effective,
a group that likes each other and don't have some paid time off of work,
though.
being, doing jury service. They might be like, "Look, I don't need to be back till mid-July."
And usually people that do decide to do jury duty are usually people that have the time.
Have the time, and you can afford to, especially on such a long trial.
Yeah.
We cannot take for granted how many of us could not work
Yeah.
for 7 weeks and
Yeah.
still comfortably be able to pay bills. That's a long time.
Yeah.
That's a lot of paychecks.
I want us to go through this verdict sheet
Okay.
because I need to have a better understanding of what we're looking at here. If you can break down for us, this is what the jury it has to fill out, correct?
Correct.
Okay.
And again, the jury is given a copy of this. It's usually filled out by the foreperson. And hopefully, the prosecution showed this to them during her closing argument and explained how to fill it out. But so here under count one,
Racketeering.
the first thing that stood out to me was that there is a unanimity, and so all 12 of them need to agree on the predicate acts, but I think it's very interesting that the first question is, "Do you find the defendant guilty or not guilty?" And then you go through and talk about what was proven and not proven.
Yeah.
Because psychologically, um, if everyone is on the same page of guilty,
Mhm.
now it's a little bit easier for us to get on the same page of the predicates,
Mm.
you know? So if we kind of already know we're yeah, it's a yes to this,
Mhm.
then they can answer all of the remaining questions kind of knowing, "Hey, we have to have at least 2, and we all have to agree on this, so where can we find some consensus?"
Okay.
Uh,
So where it says, say first, the first question there, this is how do you find the defendant not guilty or guilty? The second thing that they have there, if and only if you find the defendant guilty of count one. So they would have to find him guilty of that.
Right, and then so if you're finding him guilty, everyone has said, "Yes, there's racketeering conspiracy."
Okay.
And then these are all the predicate acts, and the question is why?
Mm.
So if they vote not guilty on this, there's no reason to go through these at all. They move on to count 2. If they found
Ah.
him guilty, they have to decide unanimously which one of these have been proven and which has not been
Mm.
proven.
Okay.
But it has to be all 12. But again, if everyone has decided that he's guilty, then you at least know we're operating from the same page in deciding whether or not this is proven or not proven. You're
Okay.
there shouldn't be as much of a fight about this because we've already said he's guilty.
Okay.
Does
And
that
for
make
those
sense?
that are listening to this, it on the document, it says, "If and only if you find the defendant guilty of count one, which types of racketeering acts do you unanimously find were involved in the offense?" So you're saying here where it says like acts involving kidnapping or acts involving arson, acts involving bribery, acts involving witness tampering, acts involving forced labor. They could technically say, okay, it wasn't proven in regards to bribery and arson, but it was proved for kidnapping and proved for
Right.
forced labor. Okay.
And here's what will be interesting, because per the statute, they have to find that 2 of them are true. It
Oh,
does not say how many they have to find are true. What if they find 1 true, but they voted guilty?
yeah.
That opens up a whole can of worms.
Okay, please explain. Oh my God.
And they have to go back, and the judge is gonna look at the jury form, and he's gonna say, "No, like, this isn't filled out correctly," and then confer with
Mhm.
the parties on how they wanna deal with that, if they're gonna re-instruct or, what that might be, but they're not given instruction, at least not on the form, that
Yeah.
you have to select 2, so it's possible they
Mm.
do something wild, and they're like, "Oh, we can all agree on this one,"
Ah, okay.
and then you're
So for
you're
under
setting yourself
here, under count one, they have to have at least the two predicates.
at least 2 need to be proved.
Okay.
And all of these have to be proved or not proved unanimously. All 12 have to agree.
Okay. On page two of the verdict sheet, they have more predicates: acts involving sex trafficking, acts involving transportation for purposes of prostitution, and acts involving drug distribution, which was one of the questions that came in
Right.
that note.
And where does that fall?
Oh, that falls under the count one of
I'm
racketeering
so
conspiracy.
blind. Now, the fact that they're considering this
Mm.
necessarily has to mean they said yes, or
Oh,
you don't need to answer this question.
oh yes. Yeah.
If they voted not guilty on racketeering, you don't have to decide anything about drug distribution,
And if we know about this, obviously Diddy's defense team knows about this.
right?
They're reeling tonight.
They might be. They might be. You can never, on one side or the other, feel truly relieved till that verdict has been read. questions are instructive to how the jury's thinking, but, unless they say something like, and sometimes they do slip and put stuff, "We've voted guilty on count 3," "We wanna know my pen is out of ink for count 4, can I use a pencil?" It's, like something
Yeah.
that obvious.
Yeah.
Otherwise, you're reading tea leaves, but if they
Wow.
are asking whether or not you
Sure.
you
What's
don't you
considered
don't need
your
to answer that question, um,
unless because again, the
unless
instructions
it's
say at the
yeah.
top,
Yeah, because
if
if you
if
said
and
not
only.
guilty, then we're not going through this exercise.
Yeah. So yeah, for those that are watching or listening, so it says under here, if and only if you find the defendant guilty of count 1, which types of racketeering acts do you unanimously find are involved in the offense? Unless they are asking that question and they're not filling out the document correctly. It
Which is a
could be that.
possibility too. Yeah, but I mean, this is the last act under the predicates for count
Yeah.
1. So, presumably, they've worked through, and presumably, they've voted guilty, and they've decided whether or not the other ones were either proved or not proved, and they're on the last one, and they need to make a decision about that.
And this is the big one.
This is the big one.
The one that everyone
Big
keeps saying
one.
that they have not proven. They have not we haven't said
Right,
that.
right. I
We
mean,
haven't
you're
said that. The
we
streets
haven't said that. We
the
haven't
streets
said
have
that.
said that. We have not said
Um,
that. That's
yeah,
big.
so I if I was a prosecution, I would be very, very cautiously optimistic,
Mm,
and if I was the defense, I'd be concerned, because my hope as the defense attorney would be that you don't even need to consider whether or not these are proven or not proven because you voted not guilty.
yeah. And this is where he can face life in prison.
Right.
And this and once the verdict is in, the judge decides on the prison
Sentencing.
sentence. Yeah.
Right. They'll both parties will submit briefs. Federal sentencing is very different from state court.
Okay.
Rather than having a triad like we do in state court, so 3 possibilities, there's a range.
Mm,
And then, his background, prior criminal history, as you mentioned, the fact that he's been on trial before, like all of those things will kind of factor in for a recommended sentence by the prosecution and then a recommended sentence by the defense, and the judge will come down on
I
his own.
mean, he's been on trial before, but he was found not guilty. Will that
Right.
still affect him?
Um, I think it's a fact that can cut both ways.
Mm,
He's been adjudicated not guilty. As the defense attorney, I'd be asking the court to not consider that because his peers didn't believe it was true. If I was a prosecution, I'd be talking about an escalating pattern of conduct
oh,
and how even after an acquittal, he didn't learn his lessons and was right back in the streets causing problems. In
mm,
fact, the acquittal emboldened him, and then we got the crimes that, he's been convicted of here. So
wow.
same fact argued 2 different ways.
So guys, if you're watching this, the one charge that everyone on these streets, but again, I think everyone has been debating this from layman's understanding and not a attorney's understanding. Even though I do believe there are some attorneys, some former prosecutors that also say they're not sure if the court has proven RICO or the prosecution has proven RICO. But again, I think this is so different. It's so complex.
It's so different, and so, again, for me, they've proven the elements. Is this the appropriate application of RICO?
Mm,
Not
mm,
has because yeah, I think it's been proven.
yeah,
I mean, we've talked ad nauseum about the acts of each one of these things. They're there if you believe the witnesses. It's, are you comfortable with a RICO in this context and
mm,
not, a mob case? And hopefully the prosecution explained it's been used for, more traditional mob type enterprises, but it's not the only application of this particular law.
yeah.
And,
And I from the summary that we did, I do feel like they were trying to explain it, but again, that was a summary, and we didn't get the full 4 hours and 49 minutes of what the prosecution was saying throughout. Let's continue and to go through the next part here,
okay,
and this is still under count 1.
right.
If and only if you find the defendant guilty of count 1, did the pattern of racketeering activity include sex trafficking of Cassandra Ventura? And then they
And
say
this
okay,
is
go ahead.
interesting because it's the same thing as
Yeah.
count 2.
Yeah, well, I don't understand why it's set up this way.
I think because it can be a standalone charge by itself, and then it can
Mm,
also be a predicate act.
mm,
And so interestingly, if and again, juries do things all the time that make no sense. But if you check yes here, it would seem necessarily that you check yes for count 2.
Mm-hmm.
But again, juries do weird things,
Yeah. Wow. So, okay. So they asked the same question in regards to if and only if the defendant, if you find the defendant guilty of count 1, did the pattern of racketeering activity include sex trafficking of Jane? So you can say either no or yes here as well. They also talked about, I remember in the closing arguments explaining that the kidnapping aspect where you see Cassie Ventura trying to leave a freak off and the fact that he was dragging her back. So they were trying to explain that could be considered kidnapping as well.
Right,
She was trying to
right.
leave. So you could see the emphasis on trying, because again, this is understanding what the concept of kidnapping is. And I know that varies from state to state, apparently.
It does vary from state to state, and although we don't for example, I can grab you from one room in your house,
Mm,
take you to another room and beat you, and I've kidnapped you. I can charge that. That's doesn't make sense to the public.
mhm.
They're like, "What," but now if I take you and put you in a car and drive you someplace else, you're like, "Oh, yeah, of course. That
Yeah.
was kidnapping." But you're always at a disadvantage as a prosecutor when you're saying, "Technically, this is a
Mm,
violation of the law." But, kidnapping is broad. It does not require a considerable distance.
yeah.
What does the appellate court call it? I wanna say aspiration. The name is escaping me, but it's not just the distance that you were taken, but the why of it all. So if you
Mm,
were drugged from the front of your house to the back of your house and you got taken to the back of the house because it's easier for the perpetrator to commit their crime against you,
yeah.
it's a stronger kidnapping versus if they just took you to the back and then tied you up and went inside.
Would also the from the 2016 incident with Cassie in that hotel, would that also be considered like sex trafficking as well? I know it's a very complicated case.
I know, and see, I'm gonna have to think about this one and text you as well.
Yes, yes.
Definitely not across. Well, actually, no, because I was in California and they live in New York, and she was brought to the hotel to have sex with a yeah,
Yeah.
yeah,
So,
could
oh my
be,
gosh, I can't with this case right now. It makes
could
my brain
be.
hurt a little bit. Count 2, sex
Okay.
trafficking of Cassandra Ventura. I think they spelled her name wrong on the yeah, I think she has 2
Is there
S's.
2 S's? Oh,
Would that be
child.
complicated for them?
And you know what's interesting on here too, Kim? Because this morning I heard that there was some sort of argument or discussion about lesser included offenses, and those aren't on here. There's no lessers. So
Oh.
that's interesting as well.
This case, man. And look, we already know for those that are just joining us, there are going to be a lot of people with their expert opinions that don't
Mhm.
have a JD, um, which is fine. This is a free country for now to have your opinion.
Not for now.
It's very
I mean,
questionable.
again, you're not wrong. You're not wrong.
But and this is why I have been emphasizing, just be mindful if you really do want to have an understanding. Because even Kirsten has says, I have a bias as a prosecutor, but she's being upfront with that. But if she could put that aside, and I think that we all can put that aside, because I've even
And
put it aside
objectively
sometimes.
look at the facts. There's some the defense scored a ton of points along the way in this trial.
Yeah, they
For
poke some
him to
holes.
get acquitted across the board, and that's the thing. Any verdict would be surprising. If he's
Yeah,
convicted of all of it, that will be shocking. If he's
yeah.
acquitted of all of it, that will be shocking. If it's a split verdict, I think that might be the only one where it's like, okay, yeah, that kind of makes sense. The
Mm,
jury split the baby.
mm,
But this came down to closing argument, and it can really go either way.
yeah.
I feel like I sound so nasally. I'm so
It's
sorry.
okay. We appreciate you
Medication has
doing
worn
this.
off.
We appreciate you doing this. And again, I mean, depending on this when this verdict comes out, you'll have to be back. So
I
get
know.
that.
Are we gonna be back speculating again tomorrow, dissecting the jury notes? Sure, I mean, it is because waiting. I can only imagine what Diddy's going through, but his
Mm,
attorneys and then the prosecution, like waiting for a verdict is just the most stressful experience, and then it always takes so long once the jury buzzes, and you hear 2 buzzers that they have a verdict, and from that buzzing to everyone in the courtroom and the forms given to the judge and them starting to read it is always takes forever. It is like the longest period of time in the world, and I feel anxious about this deliberation, and it's not my case.
Yeah.
I have, like, no stake in this, but
But
absolutely
here's the thing.
nerve-wracking.
Here's the thing, Kirsten. It will probably affect people like you when it comes to how cases like this are charged in the future.
For sure, and definitely how people analyze the
Mhm.
truthfulness of women, and I say women
Mm.
victims because there's women here, but,
Mhm.
there's a lot Amber Heard was not helpful
Yeah.
in the domestic violence context, and I mean, their situation was so wild and toxic, and I don't know, none of us know one way or the other what was really going on with the 2 of
Yeah.
them, but
Gosh. In part one of our conversation, we were talking about the work that you do in regards to domestic violence. Literally, today I saw here in New York City a woman was murdered by her husband. And there
mm,
had been a pattern of domestic violence over the years. And of course, we've talked about how this country handles domestic violence from state to state, and it's not great. And it then ends up in murder. So it's important to have these conversations. It's important to see how
absolutely.
these are playing out in court and how that will affect future cases.
An absolute tragedy, I'm really, really sorry to hear that. Did they have children? You
Oh
know?
my goodness, I'm trying to remember if they reported if she had children. I can't recall. Literally, this was like breaking news right before we got on here, and I read about this case. It literally just happened today. Count 2 and count 3. Okay, but count 2, it's the sex trafficking of Cassandra. Oh, wait, sidebar. If they misspelled her name, is that okay?
That's okay.
Okay, because then
Yeah,
never
that's
never
okay.
know. Sometimes that could be like, "Oh, no, it's
Her
misspelled."
name wasn't spelled right. Who were you talking about? Yeah.
Like, I'm not sure. I believe there's 2 S's in her name, but you guys will correct me in the comments. You always do. Okay.
Isn't it Cassandra Ventura Fine? I mean,
Well,
if
now
we're
it
being
is,
real
yeah.
technical, but
Let me see. I just have to know. Let me see.
I know we definitely see Cassie with 2 S's in it, so maybe that's where we're getting that
Oh,
from, and
no, it
Cassandra
is,
just has
it's
to be
1
fine.
S. It's 1 S. Okay,
Okay.
they got it right. Okay, we looked it up. Yeah, because Cassie, yes, she spells Cassie with 2 S's. So, we've been
That's where we're getting that from.
yeah. All right. So sex trafficking of Cassie Ventura is very clear cut here. Not guilty or guilty. How do you find the
Right,
defendant?
right.
That's count 2. Count 3. The Mann Act transportation Cassandra Ventura. Can you explain a little bit of what that is? We've talked about it before, but some people are just discovering this video today. So you can explain to the folks what the Mann Act is.
Now, the Mann Act for transportation for prostitution is Diddy taking Cassie, Jane, I don't know if Mia falls under this category, but crossing state lines with a sex worker and for them engaging in sex with a sex worker. And if I remember correctly, and thinking all the way back to last week, the instructions might have even said it doesn't even have to be a sex worker. There was something within the instruction that made it a little bit easier for the prosecution to prove.
Mm,
And it was really just about crossing state lines and engaging in some sort of sex act.
okay. And I'll include our review of what the prosecution was asking in regards to the jury instructions in the description, guys. Okay. All right. That was count 3. Let's go to the next one because there's only 5 counts, guys. And then
Right.
the very first one is the big one in regards to the RICO. So count 4, the sex trafficking of Jane, which is the pseudonym that one of Diddy's ex-girlfriends. I guess we can say ex because I guess they were broken up. Literally, right? The last time they saw each other was right before he went to prison, and he's still paying for her
Still
rent
having the
and
rent.
her attorney. Wow.
Oof, okay.
All right. How do you find the defendant for sex trafficking of Jane? Very similar to what we were talking about. And it's the same in count 5 is the Mann Act transportation of Jane as well. How do you find the defendant?
And now looking back to RICO again, they have to determine whether or not they find sex trafficking for Jane, yes or no. So again, if they find it true here, it would seem that they necessarily find it true for count 5. It will
Mm,
be very interesting if these 2 findings are inconsistent with each other,
yeah.
where
Wow.
they say, no, but guilty, or yes and not guilty, that will be interesting.
Yeah, and that's possible for them to do on these different counts to say, "Oh,
Yep,
not guilty on when it comes to Jane," because we know that there were certain jurors that did not find Jane a credible witness just based off of their body language. But
body
again, the body
language,
language is not what's
right?
determining, but they were sort of like rolling their eyes. There was one particular juror rolling her eyes. She's like, "Oh, here she goes," kind of thing.
I think that was it seemed like it was the consensus kind of all around. There was definitely some things she said that rung true and demonstrated her being victimized.
Mm,
There were some text messages that corroborated that testimony, but then there were some other things where I think the only example she gave of a violent encounter was where she, pushed his head into the marble countertop first, and then he went after her in an overly aggressive way. But there's some people, not me, but some people who are like, "Look, you hit a man, and if he pops off on you, this is what could happen."
yeah,
Especially someone who has a temper. He obviously went off the rails, if we believe the encounter the way she said it.
yeah,
But, for someone deciding guilt or not guilty, that kind of mutual combat, if you will, might not be enough for them.
yeah. So he's facing life in prison. The lesser charge, though,
In
is
total.
yeah,
I think, like, the RICO carries so much time that it would given his age, it would practically be a life sentence.
yeah. So even if the judge decided, what, 25 years?
Yeah, he's, in his mid-50s? What is he,
Yeah,
55?
it's like 55 or something like that?
Yeah, so and in federal custody, you don't ever do, like, the full percentage, but he'll do a significant chunk of that.
Wow. What's the likelihood that you see that the judge gives him life?
I think that's a very interesting question because the judge could set aside this verdict
Mm,
after the jury came back guilty. He could
mm,
say, "I sat through the trial, I listened to the evidence. I don't think based on the evidence presented
yeah.
that you could have found these counts to be true beyond a reasonable doubt, and I'm setting aside this verdict."
Whoa.
A very extreme step
Mhm,
to trump what a jury has said, but
mhm.
it's possible.
Wow,
Um,
I didn't think about that.
it's possible.
What happened with, because I didn't see any determination on the, what was it, the Rule 29 or something like that? I'm assuming he said no because they're deliberating.
Right, right. Also, another at the end of every criminal trial, it's essentially a motion to dismiss. The prosecution didn't prove its case, don't submit it to the jury, dismiss. Again, exceedingly rare,
Yeah.
exceedingly rare. Your case had to have really, really fallen apart for that kind of motion to be granted.
Okay.
But he could set aside the verdict, or, it really depends on how all of this evidence landed with him.
Mm,
Does he think it's much to do about nothing? Did
mm,
Mark Agnifalo's, flippant, dismissive take on the case resonate with him, where he's kind of felt that way too?
mm,
Or does he think that this is, decades of really bad behavior and now it's time for justice and accountability, and he's willing to give him a significant sentence? We truly won't know one way or the other until the sentencing hearing and he starts to opine. But the judge has a lot of power even post conviction in how to deal with this.
wow. Wow, you just had that in your back pocket to drop on us? Like, it was like a bomb. So the judge could literally just set aside their determination based off of his own.
Now, I have only seen this on Law& and Order, but it exists in reality. It is actually a codified power that the judges have to set aside, and actually the defense can make a motion to set aside the verdict, brief it, make
Oh,
arguments, and then
for him
and
to
they
consider.
probably will. If he's convicted, that's exactly what they're gonna do.
Okay.
It's a very extreme remedy, and it says a lot to insert himself over what 12 people came to a conclusion about. I mean, you have to have cases where the evidence was really like, "I don't know, y'all, like, this was a close call to begin with. Are you sure?" It has to be like that.
Yeah. But based off of the way that he's conducted the courtroom, I mean, I don't see it happening, to be honest.
It's hard to imagine, especially if I think he's actually only been on the bench for a couple of years, but
Yeah,
he's an
he's fairly.
experienced litigator.
I think Biden appointed him, right? I think
It's
so, yeah.
a bold move. A bold move.
Kirsten, I don't want to keep you for much longer, but I did
Okay.
ask our community some questions. So let me see if I can pull up these questions really quickly and see. I'm sure we
Sure.
answered a lot of them as well. So shout out to our members. This is one of the perks of being a member here on our YouTube channel. For those that might be listening on the podcast, we're here with Los Angeles prosecutor Kirsten Brown. Again, I will be highlighting some of our past conversations in the description as well. So let's see what they had to say. And I'm going to try and skim through some the questions. Oh, wait, I'm on the wrong thing. I'm a jig. Let me go here. Okay, for our members. Okay, I'm going to start from the bottom up. All right.
Okay.
So Denise from North Georgia said, thank you all for all you do. Can a judge enact a ruling based on the law if there is, quote, jury nullification?
No.
Okay.
So the judge has power to set aside a verdict if the jury convicts Diddy. If the jury acquits Diddy, that's it. That's the end of it. And there's no ruling that he can make that would overturn a not guilty finding by the jury.
She continued her question. She says, or can a jury decide to ignore the law and we are struck with a faulty ruling?
Yes, a juror could absolutely, all of them can.
Mm.
Jury nullification is when a juror sets aside facts, evidence, and the law and makes their own determination about how a case should come out.
And we
And
talked about that before.
right, right. It could be, another business person sitting on that panel that's like, I've been running businesses for years. I've been accused of this kind of behavior. It tends not to be true. They were seeking money, so they just came in with their mind of, I'm not convicting another businessman, or I'm not convicting another Black man, or whatever the case may be, and they end up acquitting.
And that's what they were probably hoping with juror number 6.
Probably. Yeah. Yeah, I wonder where he's living right now.
Right. We don't know. Bronx in New Jersey. I bet he's in New Jersey right now. They said also, can they bring in an alternate for juror number 25?
It would be too premature to do it right now. That is a ripe issue for appeal because the defense could say, hey, you replaced a juror who very well may have been a holdout for not guilty, and you didn't let it go past a couple of hours before you yanked him off and replaced him. That would be really, really extreme and inappropriate to do it day one. Now, if we're 4 days in and they're still sending notes out about juror 25, and then he would probably do an evidentiary hearing to find out more specifically what juror 25 is doing. Yeah. And then if there's obvious misconduct, then you can boot him, but you really need to make a solid record. And the prosecution would want that too, to protect a conviction if the jury convicts.
Based off of how the jury has been handled so far, would you say for the most part it's been decent besides the whole jury number 6 issue?
Yeah, for this length of a trial, there hasn't been too many issues, not too much drama. Hopefully that means it's
that we know of. Who knows? I can't wait for the book.
Yeah, and who knows what's happening in these deliberation rooms. But I thought when they replaced juror number 6, sometimes that can be a domino effect, and you start seeing like issue after issue after issue pop up. We had the one that immediately followed that where someone self-reported about getting a text.
Yeah.
But then it's been kind of quiet since then. So it seems like all is normal on the juror front as far as we could tell.
Yeah. Sherelle from Lancaster, Pennsylvania's question: do you think there will be a subsequent charges cases as a result of this trial? KK, other assistants, his sons. We know a couple of his sons are facing civil cases right now. But yeah, I think we've asked this question before, whether or not KK or some of the bodyguards that were not called, but
the unindicted co-conspirators. If they were going to charge them, it probably would have been smarter to do everyone at the same time.
Especially if you want to talk about building that enterprise.
Exactly, because then there's your enterprise and you get a lot less of the questions of like, how is there just one person? That's but he's at the top of the pyramid. That's why
Yeah.
there's just one person. And
And
KK isn't getting sexual gratification from the King Knight. She's acquiescing and appeasing her boss. I digress. It's possible, but it seems unlikely.
I agree with you, especially even if they do convict him on the RICO. What would be the point at this particular point? They've already got the top.
Yeah. Yeah, and it just, the idea was that Diddy was depraved and, like, was fulfilling his own needs.
Yeah.
Was was his bodyguards, or were they just, like, following instructions and, appeasing their boss rather than their own personal gratification from it? If he's cheap, who knows whether or not that he was paying him well enough. Obviously not, so bad that they're talking,
Yeah.
but it will always be a mystery where those people are and
Yeah.
why we didn't see them as witnesses or as charged co-defendants.
And again, it would have made more time. It would have made more sense to do it now as opposed to later.
Right. The stronger evidence is definitely against Diddy. I don't know that outside of text messages and conversations, we have KK putting her hands on somebody
Yeah.
or, telling Cassie she better get back in that hotel room and, spread her leg. You know what I mean?
Yeah.
She just kind of seems to
She
be
seems, if anything, one of the people to kind of at least be the middleman of trying to
right. Like,
help.
here, let me, get your IV and it's going to be okay. And,
And I don't. I know that she's been compared in Lil Rod's lawsuit as a Jaslane Maxwell, but Jaslane was literally.
she was in it.
Yeah.
She was in it.
CC from Virginia says, "Do you wait? Do you think that KK and Rock will?" No, okay. So sorry, CC, but it's very similar to the last question. I know. I think we answered your question, so we'll move on. Let me see. Daphne from Seattle says, "Does all of the jury have to vote guilty or not guilty on all the charges for a verdict?" I guess that I'm asking, can all vote guilty on one count and some vote not guilty on another count? I hope that makes sense.
Everything has to be unanimous.
Yeah.
If they can't reach a verdict, they're hung, split with some combination equaling 12. That's when they send that note out. The judge will give them what's called a dynamite instruction and say, you have to go back and try one more time. Do you want re-argument? Do you want me to reread the law? Like, what would help you? They go back and deliberate again, and they say, we still can't reach a verdict. Then you get the mistrial declared, and you potentially do it all over again.
Oof.
Otherwise, any guilty or not guilty has to be unanimous.
Yeah. I do not want a mistrial. I do not care and read of it all. I can't go through this again.
I know, but Karen Reed like felt because they were going for an acquittal, and it would depend on the split here. If there was like a 6-6 split or an 8-4 split for not guilt, something like that would embolden Diddy to do trial again. But if it's a close split, 11-1 for guilt, 10-2 for guilt, that can humble people a little bit more, and maybe they fashion a plea deal because everybody's saying we don't want to do this again. The prosecution might be saying these witnesses aren't coming back to tell the story again. So you give a little bit of a better offer, and then Diddy says, I could very well be convicted the next time. Maybe I should consider a plea.
But depending on what comes out from that.
Right.
Jocelyn, thank you so much for the question in regards to the prosecution's closing statement, but we did talk about that at length a little bit earlier. Angel says, Angel from the Bay Area, California. Thank you, Attorney Kirsten, for taking the time to answer our questions. Now that it is in the hands of the jurors, do you think the jury will be hung based off of instructions they have to follow? Laymen see it clearly guilty, but we're under the same guidelines.
The instructions can be very confusing, and I do think it's possible. Yeah, even if they were leaning towards guilt, you hear those instructions and you're like, wait, and then you start to spin out and you really start like dissecting the elements. I think it's definitely a possibility that even people who felt confident in their guilty verdict get thrown off by the complicated language that exists within jury instructions. That just makes it, I keep saying it, incumbent on the prosecution to make it crystal clear and say, write down what I told you or write down what I'm telling you, because this is how you deliberate and this is how you consider this complicated language.
Danny Wade, who's also an attorney in London, UK, asked the question, do you think it was a good strategy for the defense to call at least one witness? Have you seen this before when prosecuting similar crimes?
Yes. it is not uncommon to call no witnesses in a case like this. Usually it would be character witnesses, and we talked about this a little bit before about how ridiculous it could sound if someone's up there giving, positive character contrasted against what we just heard and then being confronted with specific acts that Diddy did. And that happens in sex cases a lot. The defendant won't testify, but he'll bring in, like a slew of friends and family to say, sometimes, well, he never touched me, or he never touched my kids, or, every time I saw him, he was in, or her, they were above reproach. And then you start confronting them and asking, like, sometimes, do you even know what he's charged with? And
Mm.
they'll be like, well, I know the gist. And I'm like, well, let me read it to you.
Oh.
And did that change your opinion? And
Yeah.
it sounds silly when people say no, it doesn't. And then it's a pointless witness when they say yes, it does.
Midwestern Jewel, thank you so much for the question from Buffalo, New York. What is or are the implications, if any, on juror number 25 with the note being sent to the judge that he's allegedly not following the instructions? And what time is Kirsten? Oh, wait, Kirsten coming on. I'm ready. You'll see this at some point on Tuesday. Okay. She's asking what are the implications of the juror number 25 not being able to follow instructions, or the question that he might not be, or she might not be able to follow instructions.
Now, if Diddy is convicted, the defense team is going to be all over this. They'll try to find out the reasons why he wasn't following directions. They'll try to get affidavits from that juror as well as other jurors and use it as a basis for an appeal, particularly if it was somebody who was a not guilty vote and somehow they seemingly got browbeaten into becoming a guilty vote. If he's acquitted, no one will ever, I mean, the media might ask if they do interviews, but legally no one is going to, it won't matter legally what was happening.
All right. So it's me, MKC, from Scotland. Okay, MK from Scotland.
Oh, look at this international crowd,
Come
Ken.
on, worldwide over here.
Yeah, shout out to folks across the pond.
Yes, and I've never been to Scotland. I would love to go.
Me too.
So she's got a couple of questions here. Hold on. Oh, more than a couple of questions. So we're going to try and get through these really quickly. Number one, how effectively do you think the prosecution presented their case? Do you feel like they established a clear narrative or leave too much room for doubt?
I think they established a narrative. I think that they hit the elements and met their burden. The open question for me is if they adequately explained, but why is it RICO? I think in video number 2, I talked about a theory of liability and very briefly a murder case where, this one was caused by a car accident and he was charged with murder. And the jury is thinking, this is really sad. People are dead, but how are we going from a car accident to a murder? And it's incumbent on the prosecution to explain that theory of liability. So the federal prosecutors here needed to make it make sense for the jury. Why is it RICO? Like, how are we using a statute that's usually used for gangsters for sex trafficking?
Yeah.
But I do think they satisfied I do think there's predicates there. I think, and just looking at the plain language of the statute, I think they met that. But there's a part 2.
And if that note was any indication, I mean, we're thinking, but
it's speculative.
Yeah.
But if you're considering that, it is indicative of some findings of guilt.
Number 2 question from all across the pond. Do you think the defense did enough to cast reasonable doubt or did their strategy feel more like damage control? I think we kind of answered that, but you can, if you wanted to weigh in more.
I think Cassie withstood cross-examination really well. I think like the Kid Cudi, her mother obviously wasn't, questioned at all. But I think towards the second half of the trial, the defense did an effective job of cross-examination and then turning, in their mind, what was a prosecution witness into a witness for them, like with some of his personal assistants, the one who was considered the drug mule, and trying to get in the good facts about Diddy that they wanted to argue later. But there was plenty of defense. I call it fodder, and by fodder, I mean room for them to argue about the credibility of the witnesses and to a certain extent the appropriateness of the charges without crossing the line that the judge indicated.
Yeah. Number 3, were there any key moments like cross-examinations, evidence reveals, witness testimonies, or closing arguments that you feel likely swayed the jury significantly?
Thinking back, there was the one issue with who was the witness that said she was dangled off of the balcony.
Oh, Brianna.
And then Tenny Garagos kind of had that moment of, having a receipt that Diddy wasn't even there.
Yeah. You're in New York, not in LA.
Right. I think that was kind of a ooh moment.
Yeah.
What didn't get reported as well is that the prosecution cleaned that up in terms of the timing. Because I think the judge said it. This is 10 years ago. And if somebody was off by a day or two, a month or two, or whatever, like, are you going to say because it didn't happen on this day at this time that it never happened at all? Or could someone who was admittedly an addict at the time get skewed in their thinking? So there was a couple of moments like that where they kind of got someone and it was like, oh, okay.
Worth the millions that we're paying for you.
Yeah, you are putting points on the board and giving us something to argue when it comes down to closing.
Number 4, based on the evidence and courtroom dynamics, what do you think the jury is most likely grappling with in deliberations? Okay, with these questions.
That's very good questions, but almost impossible for us to answer because we're not in the courtroom.
Yeah.
So it's hard to know what they're grappling with, or when they made faces, or when they nodded in agreement, or what witnesses they chuckled at, and what witness they looked irritated by, or who seemed like they were on the stand for too long. You really have to be in the room to understand all of that. But, I would have thought that RICO was something they were going to grapple with, but
that note, I'm telling you, I'm like, wait a
unless
minute.
you're working up.
I mean, again, because they have the freedom to handle
any way but it doesn't make sense to be talking about the predicates if you haven't found him guilty. That it's a waste. And if they're wanting to get home for the 4th, it's literally like there's no need. There's no need.
Yeah. I'm just thinking to myself, like, I have a feeling if what we're saying and feeling is true, I feel like we will have a verdict tomorrow.
Yeah, because that's, and they're answering 2 of the counts within count 1, by basically the yes or no questions are allegations, and they have to answer those within count 1.
Yeah.
So if it's a yes or no, then it makes it a little bit easier to move on down the line. Interesting. It easy to fill out verdict form, but also the redundancy in it makes it for an interesting possibility of some split verdicts if they don't find guilty on everything.
Question number 5. Do you think public opinion or media coverage may subconsciously influence the jury despite instructions to ignore it?
If they didn't ignore it, you know what? And that's another thing they could have been reporting about juror number 25. It couldn't have been about how he was voting. It could have been like he came in and said, "I saw on the news, da 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 da," or "I was watching KEMPIRE, da 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 da."
Or they were discussing it on the train.
Right. So
I had someone that was working in my apartment talking about the case, and we led into this big conversation. So people are having conversations about it.
People are having conversations. So the question is, does anybody, knowing they were not allowed to get outside influences, do they disclose that in the jury room? Or did they do it low key and then you keep it to yourself? And then where you're getting your content from matters significantly. It really depends on. News outlets have been pretty neutral, if not skewed a little more towards the prosecution, in my opinion.
Yeah.
But there's a lot of content creators that are very, very split, and you can find your niche for whatever your opinion is about the case. There is somebody out there, providing that type of analysis. So where you get your content, if you are ignoring the judge's rules about consuming content, is going to be very instructive for how it's impacting your deliberations.
And if you're a juror watching this after your deliberations,
I know.
I would love to hear your perspective.
Hey.
All right. All right. So Shea from Atlanta, Georgia. Thank you, Attorney Kirsten and Kempire, for this Q&A. If juror number 25 continues to ignore instructions, can the judge replace him with an alternate? Can he face obstruction charges? Oh,
He likely wouldn't face obstruction charges unless he's doing something really, really out of pocket.
yeah.
If after the judge presumably admonished him today, if it's happening repeatedly, like over the course of days, I think he could be ultimately replaced.
Yeah.
But it's
We talked
going
about the alternates.
yeah,
They're still
it's
there.
gonna have to take a lot because of the appellate issue that's created by substituting out a juror.
Which we've talked about in part 1 and part 2 of some
Right,
of the moves for a mistrial that's intentional for appeal.
right.
Kimberly from the DMV. Hi, Kirsten and Kempire. Thank you so much for allowing us to ask questions. I apologize in advance for all of my questions. No, we love the questions.
I
I apologize to you,
love the
Kirsten, for taking because
question.
I know you're still in the office and now you want to get home.
No, listen, I'm sure my husband is like, "Where are you?" But I
Sorry, husband. I'm always getting involved in people's marriages. I'm sorry. The judge issued a 40-page 60 plus pages
mm,
instruction booklet today. Can you unpack the most critical parts for viewers? We don't have access to that.
right, we don't. We can only it's a part of the court file, but I don't know that it will get released publicly.
Okay.
Look back at the unanimity conversation. I think that that's probably one of the more pivotal instructions that
And I didn't even think about I had to had to have an attorney bring that up. And I'm sure there are probably a lot of people talking about this that are not bringing that up.
yeah, I mean, it's not something that you're gonna notice or pay attention to unless you've discussed jury instructions before.
Mm,
It's not even something that would cross your mind that there are components that there does not have to be a unanimous finding for. And if I can lower my burden as a prosecutor legally, I am 100% doing that.
mm,
I think that part's going to be huge. How terms like drug distribution, which came back as a question already, are going to be huge. So sometimes it's just the definition of terms that sound different than layman's or just how we communicate with each other day to
mm,
day versus the legal definition that might exist. Like drug distribution could be me handing you an ecstasy pill
mm.
for purposes of the law in this particular case.
Yeah. I think we may have answered this question, but I'll ask it. The prosecution told jurors that they don't have to agree on every predicate act, which we talked about. Can you break down what that means?
But they do. I mean, but that was a point of contention.
Yeah.
Here it says specifically, if and only if you find the defendant guilty of count 1, which types of racketeering acts do you unanimously find were involved? So that tells us all 12 have to agree that it's proved or not proved.
Mm,
If that word unanimous wasn't there, game changer. Game
and that's what we were
changer.
talking about. That I didn't even think about that until you pointed it out in regards to when we were reading through what the prosecution was trying to have.
Yeah.
Hmm. Okay. Question number 3, was the prosecution's closing design more for emotion, logic, or a blend? And why does that matter with this jury? I think that's hard for us to determine because we only will get like a transcript of it. We weren't in the
Right.
actual courtroom.
Just based on reporting from in your recap
Reenactment.
was yeah, it
If
was
only.
very thorough and very good, and the consensus was that it was a methodical,
Yeah.
boring, just straight down A, B, C, D type of closing argument. Every prosecutor has a style, and you need to be uniquely who you are,
Mm,
not trying to put on airs. If you are a prosecutor and you're not Mark Agnifilo, who can get up there and be like eccentric and all over the place, the jury will read that you're being inauthentic, and it does, they're not going to like it.
mm,
So if her way was to just methodically walk through the facts, then that's going to be the most powerful presentation to the jury, being your authentic self as a
mm.
lawyer. As we like people, you want to see authenticity.
Yep.
And I've seen some very, very methodical prosecutors. I'm much more flowery and dramatic. That's my nature, but I still have to bring it home and prove the case.
Yeah.
But I've seen some other people who to give very methodical closing arguments, and I've thought like, I wish I could do that as well.
Mm, mm. She's where's the other question?
And lastly on that,
Mm.
who your jury is matters. And we know we had some engineers, we have somebody in finance. If if you have technical language matters, I parse words for a living, or I analyze things for a living type jurors, then yeah, you can't be up there talking about remember when Cassie cried. That doesn't compute for them. You
Yeah.
need to be laying out the specific facts.
Mm.
So,
Okay.
given the makeup of this panel, she might have been a really good choice to be methodical and thorough.
Okay. All right. How do you balance sensational evidence like the freak off videos with legal clarity in a jury trial?
You have to explain the why.
Mm,
Jurors can also see through, well, first of all, irrelevant or purely sensational evidence is probably not getting admitted. You can't just again, I won't give the specifics of the trial I'm in because it's actually happening. I have a lot of sensational yet not relevant evidence.
mm,
And if the judge did allow it in, basis for appeal, potential conviction overturning, because your evidence cannot be more prejudicial than it is probative.
mm.
I hope that makes sense.
Yeah.
So if you're showing just like not relevant, but wild stuff that Diddy's doing. Like, for example, clips from Making the Band.
Yeah.
He wasn't on trial for, yelling at his assistants. But if I decided, oh, I want to show you've had a pattern of acting wild, like that's not relevant to this case.
Hmm.
That would be sensational. And the jury might very well be wondering what is this? Why are you wasting our time with things that don't go to the elements of the offense?
Mm.
So sensational evidence can be great because it's emotional, like that Cassie video,
Yeah.
but you have to tie it to an element. And in order to get it admitted into evidence, you have to tell the judge the why of it all, and then you have to tell the jury the why of it all, and what this evidence proves in terms of your case.
Some of the questions that Kimberly also asked, I believe we answered, and we can't necessarily answer in regards to the jury instructions because we don't have access to them. And I believe we've answered this, but I'll read it. She says, could the judge remove a juror this late in the process if uncooperative?
With a record and having admonished that juror and making sure that the judge has exhausted all options to get the juror's cooperation. It couldn't happen with one note coming out or even after just one day. I don't think that would be enough to withstand in a potential overturning on appeal.
Okay. Okay. Kimberly, I'm going to come back to some of your questions. Let me just double check to see if anyone else had questions. Okay, no, there were only trial for. Has this been proven at all? I think Deja from Maryland, you had a question about what he's on trial for. Has this been proven at all? Will he walk? I think we've talked a lot about what we think or believe has been proven, but again, that will be determined on the judge. Whoa, Kimberly, you had quite a few questions here. Let's see if there's anything here or necessarily that we haven't answered. I just want to kind of skim through this. But while I do that, guys, if you're watching this on YouTube, be sure to like the video. Be sure to share this. If you're listening to the audio version of this, be sure to give us a 5-star rating. And if you're listening on Spotify, you can ask questions there and comment there on Spotify. So be sure to let us know your thoughts on what we're talking about in regards to the Sean Diddy Combs trial. Okay. Ooh, how do prosecutors weigh the optics and influence of who becomes the foreperson? We talked about it. It's not up to the
Not up to the prosecution. The jury votes on who their foreperson is. We have no sway whatsoever. And in fact, unless they're sending notes out, we wouldn't even know until the verdict came back.
Okay. And so that takes away from some of these other questions.
But we always take a poll. You always guess with the
Mm,
court staff. And, if you have a good relationship with the defense attorney, we always take wagers on who we think the foreperson is going to be.
mm,
It's an interesting way to chit chat while we're waiting for verdicts.
yeah. This is a good question. If you were the defense attorney in this case, we talked a little bit early in our conversation. If you were the defense attorney in this case, what would you have done differently?
I might have conceded a lesser count and
Oh,
focused heavily on RICO. I like to call that creating a permission structure, creating a place for the jury to put all of the bad facts and bad evidence and crazy information they heard about Diddy and, concede something. So it's like, okay, yes, we can all admit he did some bad things and this is the crime it is, but it's not this. I probably would have done that with one of the counts that he could potentially get time served for.
Okay.
I would have gotten in and out quicker on cross-examination with some of the witnesses instead of meandering around. Like, pick your spots. What do you want to hit them about and get in and get out to get them off the stand quicker?
Yeah.
And for closing, I think I've discussed this ad nauseum. I would not have been as flippant as Mark Agnifilo was, because as I mentioned a moment ago, that's not my style.
Yeah. But I'm just want to make sure that, because some of this we've already sort of talked about, and again, I've kept you here over 2 hours yet again. Not surprising, but again, guys, I will ask you again because Kirsten will definitely be back, so we can talk about the verdict.
I could truly. This is so fascinating, and I mean, I can talk about work and my job in this system, and like all day, all day. It is something that I'm passionate about and feel strongly about, and to put this in the context of something in the culture to talk to a broader audience about, I find it very enjoyable. So I think it's great, and I'm just so thankful that you've had me on the pod to talk about this and give me an outlet so that my friends and family could be like, shut up.
But watch, they'll be the first
Nobody asked
watching.
you. Yeah, nobody asked you except my mom, who she's a new listener of yours, loves your podcast, and said, you guys have great chemistry. And I said, you're right, Mom.
We do. And that's hard. That's hard to determine. I'm so glad that and grateful that you reached out, because I've collaborated with other attorneys before, and we have fantastic people that have been on, but I really was interested in hearing your perspective, especially as a LA prosecutor. And it really has given me a whole other education on the other side of things. This will be very interesting because, as I said before, you're going to have to come back so that we can react to the verdict.
I know. Are you going to go live because you'll have time? They take it. Although the judge did say he's going to move it along when they say they have the verdict. He's not going to be waiting on everybody to pile in the courtroom, but you should at least have a few minutes to get set up.
Yeah. I definitely would that would probably be the one time that we will go live, and I'll take callers and things like that. But to hear people's reaction. If you're, I'll text you just in case. I was like, if you're free, you want to come.
Nervous. I don't like. Why am I nervous about this? I don't know.
No, I can understand the nervousness behind it, because I think because it's such a very different case, I think it will affect future cases to come. It's going to affect the culture.
For sure. There's so much.
It's a huge case. And we appreciate you at least educating us on the prosecutorial aspect of this, but also the legal aspect of this.
I'm happy to. I'm glad that it has been helpful for you and your community, and I welcome the questions. And again, it's my opinion, but my opinion is also based on well over a decade of experience. So it's not, just coming from nowhere, but my opinion is not the be all end all. Ultimately, it's up to the jury.
Yeah.
And there's a lot of what's also beautiful about the legal process is great minds disagreeing about the same set of facts or the same law and having different interpretations. This is why we have trials. If everybody was on the same page about the same evidence, then what are we talking about? So I am not looking here to indoctrinate or just throw my thoughts and feelings out without getting any pushback or answering the challenging questions or thinking about it from another perspective. And I'll say too, you, Kemp, your listeners, you are all jurors. And so how you think, process, feel, interpret is the same way people sitting on a jury do. And hopefully, if any of you ever have the privilege of being on a jury, and I call it a privilege, you'll remember this moment and how critical you are to the system. So every opinion, it's easy to dismiss people on the internet, but and especially in California, ain't no limitations on who can be a juror. Felon, like everybody. Like how you digest this information is also instructive to me in my real job, because you could be sitting on one of my panels one day or someone like you. And so understanding how you think and how you need to hear evidence is important. And it's been really, really helpful for me to have these conversations with you as well.
Oh, I love that. On a fun note, ending this on a fun note, if you had a prediction, because I already predicted, I believe they will come back based off that note. I've predicted that maybe we'll get a verdict tomorrow. If you, based on your experience, do you think that do you think we'll get a verdict? Will it be this week?
I'm leaning towards Wednesday.
Okay.
And again, this is just my gut is telling me split verdict where they're going to acquit on Cassie counts.
Okay.
Yeah, convict on Cassie counts and acquit on Jane.
Because they didn't feel like, I think we all felt like she wasn't the strongest witness.
Right. And sometimes the jurors are like, it's bad and we think he did it, but you don't want to do everything. And Mark Agnifilo is, alluding to, how significant all this is. And so it's like, let's convict him of something, but let's give the defense something too, because they did a good job and we're not really sure about her. So we can acquit on that charge. That kind of thinking happens as well.
And one other thing that I want to mention in regards to Jane, when I say that Jane, I don't think that Jane was the strongest witness, doesn't mean that I don't think that she wasn't a victim.
Right.
That's important to emphasize, because I think
you are absolutely right.
People have tried to demonize her on the internet. I still think that she was a victim. Do I think she was the best witness? Not necessarily.
And you can't discount how extraordinarily difficult it is for any witness, let alone one in a high-profile case, to sit in a packed courtroom and talk about their sex life.
Yeah.
Whether you're talking about what was consensual or what was non-consensual, I don't think any one of us want to sit down. No part of our conversation would be cool if we were like, tell me about, last night and, whether it was consensual or not and all the things. So it's difficult. And
everyone trying to dox her on, and in my coverage of that, I said, I know it's very obvious, but she is a victim and she's testifying under pseudonym. Don't dox her information.
Which was your other question about Mark Agnifilo not wanting to refer to her as Mia, but instead saying, I'll refer to her as the witness who testified under the name Mia. Now, come on. There is provisions that exist within the law that allow a victim of a sexual assault to testify under a pseudonym or have their case filed under a pseudonym. It didn't start with Diddy. It's not going to end with Diddy. Like, it's fine if you don't believe her, but you're not going to be disrespectful.
Yeah.
And that's just another one of those comments where it's also like, how this works, Mark. You know how it works. So stop trying to imply otherwise. But it was a little jab at her credibility, right?
Yeah.
Like, if she can't even tell you her name, how can you really believe her? That was the underlying, sentiment in that.
And the element, the strategy there, you could say, like, even though the judge was like, you can't consider that, it could be still impressive.
They heard it. You can't unring a bell, and they heard it. And so that's not a dig you needed to make. Again, in my opinion.
No.
But people on the jury could have felt different.
This will be an interesting case. Once we get the final verdict, Kirsten, as always, we appreciate you taking the time out for an over 2 hour and 15-minute conversation.
Oh, you know what we need to do is start turning this into happy hour.
Right.
I don't know why we're sitting here with tea and water. Well, I do. And, this could have got a whole lot more interesting with the margarita in my Margarita Monday.
Right. Look, sorry. Next time, drinks are on me. Drinks are on me. Kirsten Brown, thank you so much for being here, guys. Again, don't forget to like the video. Don't forget, if you're listening, to give us a 5-star review if you enjoy the content that we're doing. You can find our Diddy trial playlist available on YouTube, but you can also find extended versions of the Diddy trial updates on the KEMPIRE podcast. Kirsten Brown, thank you so much for being here yet again.
Thank you, Kemp. My absolute pleasure. We'll be in communication tomorrow.
Oh, without a doubt. And guys, if you missed part 1 and part 2 of our conversations, it really is important to go back. I know we've covered a lot in this one, but go listen to part 1 and part 2. There's so much that every time I did my references in regards to the summaries that we were doing, I said, please go back and listen to that. Please go back and listen to that, because I think that was really important, because it will make you look at this case very differently.
Right. I agree.
Thank you, Kirsten.
You're welcome.
Here we go now.